In this proceeding to transfer guardianship and custody of an infant, respondent mother moves to vacate the court's order that she undergo psychiatric examination on the ground of her Fifth Amendment privilege against compulsory self-incrimination. The infant herein was born May 11, 1972, and has been in the care of petitioning agency since April 17, 1973. Her father has signed a surrender for her adoption. Her mother is alleged to have suffered continuously from serious mental illness, which, if proved, is a ground for dispensing with parental consent to adoption. The petition is brought pursuant to Social Services Law, Section 384, paren 7, which provides in pertinent part, if the parent whose consent would otherwise be required under this section be determined to be presently and for the foreseeable future unable to provide proper and adequate care by reason of mental illness or mental retardation for a destitute or dependent child who has been in the care of an authorized agency for not less than 1 year immediately prior to the institution of a proceeding pursuant to this subdivision 7, the guardianship of the person and the custody of such child may, if the best interests of the child so require, be committed to an authorized agency by order of the family court. Mental illness means an affliction with a mental disease or mental condition which is manifested by a disorder or disturbance in behavior, feeling, thinking, or judgment to such an extent that if such child were placed in or returned to the custody of the parent, the child's physical, mental, or emotional well-being would be endangered. The court ordered that respondents submit to a psychiatric examination in accordance with SSL Section 384, paren 7, paren G, which mandates, in every case the judge shall cause the parent to be examined by and shall take the testimony of a psychiatrist in the case of a parent alleged to be mentally ill to be appointed by the court. The court conceives respondent's objection to the plain words of the statute, supra, as a twofold claim of denial of her privilege against self-incrimination. On the one hand, she claims the privilege for any statements made to the psychiatrist which might reveal a crime or tend to connect her with a criminal act. More fundamentally, she is asking the court to treat mental illness as equivalent to a crime, since proof of that condition will have grave consequences for her, and to expand the privilege to information given a psychiatrist which might prove mental illness. The privilege against self-incrimination applies to testimony and communications in civil as well as criminal litigation, but it does not limit the compulsion of conduct or non-testimonial evidence. The New York courts have not hesitated to compel psychiatric examinations when relevant to the action. People versus Truck, 170, New York, 203. 63, Northeastern 281. People versus Kemmler, 119, New York, 580. 24, Northeastern 9. People versus Blank, 64, Miscellaneous 2nd, 730. 315, New York Supplement 2nd, 647. In applying the testimony conduct distinction, the courts have protected the accused by treating developments made to the psychiatrist as a verbal act relevant only to the issue of mental condition and not as evidence of the truth or falsity of the facts asserted. People, the United States versus Baird and People versus Laudati, any incriminating statement made by respondent during psychiatric examination would be similarly protected. In order for the claim of privilege to be honored, the threat posed must be criminal. Matter of Zuckerman, 20, New York 2nd, 430. 285, New York Supplement 2nd, 1. 231, Northeastern 2nd, 718. A finding of mental illness in this proceeding cannot subject respondent to either criminal penalty or loss of freedom. Social Services Law, Section 384, paren 7, contains no criminal sanctions, and the psychiatric examination cannot expose her to criminal prosecution. Nor can statements be made by respondent to the psychiatrist as evidence against her in a civil commitment proceeding, since any order herein, together with the papers on which it is based, must be sealed. SSL, Section 384, paren 7, paren E, and a determination of mental illness shall in no way affect any other right or constitute an adjudication of the legal status of the parent.